Hello, my name is Albert Stoll. This video discusses how to identify, evaluate, and prove dangerous public road cases. My 16 years of experience working on car accident cases has taught myself and the team of lawyers I work with that these cases, or any car accident case, needs to be evaluated from three different perspectives. Driver error, how did the vehicle perform, and was there something about the road or intersection in terms of the way it was designed that contributed to what happened. Today we're going to be talking about that third point, which is how to defeat government design immunity in a dangerous public road case. When these cases first come into your office, they don't necessarily pop out as cases against government entities. Typically, you're focused on the driver negligence. So the first thing that you need to do is go to the scene and have a look. This is United States Highway 101 south near Prunedale in Monterey County. Here, a common occurrence with cars turning left is that traffic will back up and form a line during rush hour, and the car attempting to turn left is faced with very dense freeway speed traffic that they have to maneuver through to complete the left turn. This may be a situation where you can prove a case against a government entity. If you want to start to go down that path, you need to look at two statutes that govern this situation. The first statute deals with timing. It's Government Code Section 911.2, which says if you're going to make a claim or sue the government, you need to do it within 6 months of the date of the accident. The other deals with a limited design immunity that the legislature has provided government entities in Government Code Section 830.6. Government Code Section 830.6 provides for a limited design immunity if the government entity can show discretionary approval of a road or intersection in advance of construction. The rationale for this law is that juries, according to the legislature, shouldn't be second-guessing the decisions of traffic engineers who allegedly weighed the pros and cons of a particular design before construction. The next step to take to determine if the limited immunity even applies is to get the plans or drawings of the intersection. If you can show that there are no plans or the plans are incomplete, the immunity doesn't even apply. Here's an example we came across in San Francisco. This is the intersection of Geary and Fillmore Streets. And the issue in this case was this traffic signal confusing to the residents or pedestrians who use this intersection? So we asked the city to send us their plans, and what we found were the plans were incomplete. They didn't show where the stoplight was supposed to be placed or how it was supposed to be angled. There was no showing that any traffic engineer thought about the pros or cons of how this intersection should look before it was built. So the rationale for design immunity was defeated. Another way to defeat design immunity is to look for a claim that's independent of the design in question. This came up in the case of Cameron versus the state of California. In Cameron, the plaintiff's lawyer didn't attack the design of the road, but he alleged that the dangerous condition that the driver was presented with was not warned of. In Cameron, that was a hard-to-maneuver curve that had no warning signs before the driver approached it. So the failure to warn of the hard-to-maneuver curve is independent of the road's design, hence the limited immunity of Government Code Section 830.6 is defeated. Another way to defeat government design immunity is to show that there's been significant changes to the road or intersection. Typically, this is shown by increased traffic or primarily increased accidents in the area. One of the sources of evidence of accidents on a particular road or intersection is SWITRS, the statewide integrated traffic record system. You can request all of the accidents from the state of California for a particular road or intersection and make the argument that the public entity was on notice that there were an aberrant or abnormally high amount of accidents in this area. But remember, the SWITRS data is not necessarily complete. There are a lot of accidents that aren't reported to SWITRS because there's no formal police report. For example, fender benders where nobody's hurt, or there may be muni accidents or accidents involving the public transit agency that they investigate. Those aren't reported to SWITers. So it's important to do your own investigation, go to the scene, talk to business owners, pedestrians who live in the area, and most importantly, secure all of the 911 calls from a particular road or intersection. There's a tremendous database now that the 911 system collects from people calling in on cell phones reporting accidents in areas. Those records should be requested as well. The idea here is to collect evidence of accidents to show that the government entity responsible for this area should have known that something needed to be done to fix the situation. So once you prove notice because of all the accidents, you can defeat government design immunity. To learn more about defeating design immunity, read the article written by myself, Walter Haynes, and Sharon Arkin entitled Identifying, Evaluating, and Proving Dangerous Public Road Cases. This article is available on our website. My name's Albert Stoll. Thanks for watching, and feel free to call anytime.